June Pereira.
Question 6.
Mr. Speaker, I thank the member for the question. Members know that the law provides for stiff action to be taken, and stiff action is taken against sex offenders, and recalcitrant sex offenders receive even heavier sentences. These include longer imprisonment terms, sentences under the corrective training or CT and preventive detention or PD regimes. Under both CT and PD, repeat offenders can be sentenced to imprisonment terms which are longer than the maximum term prescribed for the offense. CT sentences can range from 5 to 14 years, and PD sentences can range from 7 to 14 years. And such offenders also undergo longer rehab programs and supervision. And members know that we have been extremely focused on this, proactive, always looking to see what else we can do to try and protect members of the public, particularly vulnerable members of the public. And I had asked MHA and MINLAW to study a new sentencing option, quite a novel approach to give more protection to the public from dangerous first-time offenders as well as repeat offenders who commit very serious hurt and sexual offenders. The proposal is not quite fleshed out yet, but the framework of the outline is that offenders will have to serve the minimum jail sentence, which could be anywhere between 5 to 20 years. But at when the jail sentence is and they've completed it, there will be no automatic release. At the point of release, they have to be assessed as to whether they pose a threat to the public. If they are assessed to continue to pose a threat, they will continue to be detained. This, as members can see, would represent a major change in the way our sentencing regime works, because today the court imposes a sentence and when it ends, the person is released. The United Kingdom tried this approach, I have to say, with very mixed results, but I think we can make it work. And the rationale is very simple. A person commits an offense, it's a serious, heinous offense, say raping a young child, or rape followed by murder. The judge can express outrage. He can impose a very stiff sentence, assuming it's not capital punishment. But the judge will not know whether in X number of years the person will no longer remain a danger to society. And there have been enough cases around the world where the day after the person is released, literally, he goes out and commits another serious offense. We have had, not many, but we have had 1 or 2 cases in Singapore too. And so really you can only assess this or some of these cases at the point of release. So we sought public feedback on these proposals in July of last year. We are considering our approach. Obviously, we'll come back to the House because any such approach is going to require changes to the law. In addition to the above, agencies like the Ministry of Education, MSF, work closely with the police to screen those who apply for jobs when they have to work with children in licensed preschools and schools. The member suggested that MHA consider lifelong counseling and monitoring of recalcitrant sex offenders. Today, a sex offender is given psychological assistance by the Singapore Prison Services psychologist. Those who have committed serious sexual offenses can also be put on the mandatory aftercare scheme, or MAS. The MAS provides community support, counseling, case management, with supervision for up to 2 years for inmates who are released and who are at higher risk of reoffending or who are in need of more reintegration and support. SPS, the prison service, also works closely with the families of ex-offenders and community partners to support them after their release. We will refer the members' suggestion to consider lifelong counseling and monitoring for recalcitrant sex offenders to the relevant agencies for them to consider. Thank you, sir.
Ms. Pereira.
Thanks, Speaker. Thanks, Minister, for your reply. I have one SQ. May I know, in scenarios where they are convicted pedophiles, are there any safeguards or precautions to prevent them from working with children? Thank you.
The safeguards are in licensed vocations, regulated industries, institutions. I mentioned MOE registered kindergartens and schools. So employees at these licensed childhood centers, regulated by MSF or ECTA, must be screened. But those who work in enrichment centers or commercials or other commercial service providers for children do not need to be screened in today's framework. And even then, even in licensed premises, the question is whether all employees need to be screened, for example, cleaners and so on. We know that MOE does a screening for all, including cleaners, but others may not. I've asked my ministries, MHA, to look at the screening framework to see how the process can be strengthened, but we need to have a balance between making sure that people have a second chance, but at the same time protecting the vulnerable. There are some not so easy issues to consider. For example, what about freelance providers of services, piano teachers or swimming coaches? So the regulatory framework for that is not so easy to consider, but we will look at it and we'll come back before the House. Thank you.
Mr. Pritam Singh.
Thank you, Mr. Speaker. Minister, just a quick question. I understand this is still a review that is in progress and the full details of the proposals are not before the House, but I would like to ask for current offenders who are incarcerated because they've committed serious sexual crimes. Are they, in the course of their custodial sentence, are there constant reviews done as to their reintegration later into the public after they've served their sentences? Is that being done currently? And in terms of the numbers of individuals that we're looking at in currently serving sentences, how many people would the Minister estimate come under the regime based on whatever existing data the government has? Thank you.
Now, the first question, as I understand it, is are we assessing the current detainees, people who are in jail, for their reintegration back into society? Now, this is, as I've said many times in this House and outside, this is a matter of a very serious focus for the Home Team and the prison services, in that we focus a lot on rehabilitation. And in order to do rehabilitation, when someone who has been imposed with a custodial sentence comes into prisons, he or she is assessed on a certain matrix of factors to see what sort of intervention is necessary to help the person. And without going into too much detail, they may be classified as low risk, medium risk, high risk, for example. And depending on the total set of factors, including the risk within prison and outside, they are given tailored interventions and assistance, job training, education, you name it, different things. Of course, some, based on our assessment, are not suitable for immediate job training, for example. They need other sorts of intervention. First, to get them to be in a place where they can be better rehabilitated. So there are a whole series of factors and approaches, and it's done through the period of detention. But of course, some, if they are in there for 3 months or 6 months, then these approaches don't work. We are talking about detainees or people in jail for a longer period of time and assessed to be in need of such assistance. So when they come out, we no longer take the approach that you're out and therefore you're no longer my obligation. We have the YRSG takes a very detailed approach to try and get them jobs and place them on jobs when they leave, and continue with other agencies to try and handhold and assist them thereafter. I'm not saying that it works for every releasee. Some don't want to know us, and obviously there is a lot of us. This only works on the basis of consent. And some will not keep in touch. But for those who need assistance, and again, we don't have the full set of resources to assist everyone, but we try and do our best for as many as we can. So that's I think I'm answering the question that was asked. Unless the leader's question is, do we assess the risk of reoffending in the way that I've described for the future? That's part of the assessment, but I'm unable to give the numbers because the leader can file a separate question on that if he wishes.